Before panic.
So, good morning, my lady, good morning. The court has a list of those appearing, so I won't read out the names. The appeal raises an important question, whether the court has power to direct a member of a charitable company, Dr. Lehtimaki, the first respondent, to implement the court's decision that a specific transaction is in the interests of the charity. And my lord, we make three main submissions to the court. First, we will say that the court has power to decide whether the grant in issue is in the interests of this charity, and especially so in a case such as this, where the charity itself and the Charity Commission have asked the court to decide whether the grant is in the interests of the charity. So the Chancellor had power to decide that question. Our second submission will be that the Court of Appeal was correct to find that Dr. Lehtimaki, as a member of the charitable corporation, is part of the administration of the charity with no personal interest to protect, and therefore we submit the court had power to direct the member to implement the decision of the court, given that the court had been asked by the charity and by the Charity Commission to decide whether the grant is in the interests of the charity. And the third submission that we, and in relation to that second submission, we say this is so whether or not the member is to be described as a fiduciary. But if necessary, we say that the Court of Appeal correctly decided that the member is a fiduciary in the circumstances of this case. Our third submission is that Section 217 of the Companies Act, read with Section 201 of the Charities Act, does not remove the powers of the court to give directions to the member in the circumstances of this case. That the statute requires a decision by the member does not exclude the powers of the court to direct the member as to how to perform his function. That is because Section 217 does not exclude the jurisdiction of the court, the powers of the court, either expressly or by necessary implication. So those are the three matters I want to focus upon. The court has seen the background to these proceedings. The independent trustees of the charity CIF, as long ago as the 14th of April 2015, agreed with the two founding trustees, Sir Christopher Hone and Miss Cooper, to make a grant of $360 million to a new charitable foundation established by the appellant in the exercise of the charity's grant-making powers, but subject to the approval of the Commission and, if necessary, the court. The Chancellor noted that the Commission had decided that it would not decide the question. It exercised its statutory powers to authorise an application to be made to the court. The court heard from all relevant persons, including Dr. Lehtimaki. It heard from counsel for the Attorney General, who supported the making of the grant, and the Chancellor decided in the circumstances of this case it is in the interests of the charity to make the grant. This was, the Chancellor held, a sensible way of resolving what the Chancellor described, it's paragraph 128 Roman 3 of the judgment, MS 290, as, I quote, this incredibly hostile dispute and the governance problems that it has created for CIF. And that is the dispute between the two founders of the charity, formerly husband and wife. Paragraph 8 of the Statement of Facts and Issues, I don't invite the court to turn it up, I'm sure the court has read it, MS 73, recognised, paragraph 8 of the Statement of Facts and Issues, recognised these problems were giving rise to, I quote, real difficulties in the management of SIF, and they were damaging the effective performance of the charity. And there's evidence on that, if the court needs it, in the witness statement of the former chairman of the trustees, Lord Malloch Brown, paragraph 17 to 18 and paragraph 44 at MS 224. Sorry, MS 328. MS 224 is paragraph 12 of the judgment of the Court of Appeal, which refers to these matters. The Chancellor's conclusion that the grant is in the interests of the charity is not challenged on this appeal, and indeed was not challenged in the court below, in the Court of Appeal. And that's expressly stated in the agreed statement of facts and issues. Perhaps we could just look at that. It's MS 74, the agreed statement of facts and issues, paragraph 11, 74 of the agreed statement. At first instance, the Chancellor approved the making of the grant as being in the best interests of SIF. None of the parties has challenged this finding. I should mention that Dr. Lehtimaki says in his written case, it's paragraphs 109 to 113, MS 133, that he says he was able to play only a, quote, very limited role, unquote, at the hearing before the Chancellor. But as the court appreciates, he did not appeal against being joined to the action. The Chancellor set out his reasons for joining Dr. Lehtimaki at paragraphs 58 to 63 of the judgment, which is Appendix Tab 4, MS 272 to 273. And there was no appeal from the joinder, no complaint in relation to that, other than the general complaint that's now made. So the question, as the Chancellor said, it's paragraph 151 of the judgment, the question is whether a single member, that's Dr. Lehtimaki, has, as the Chancellor put it, effectively the power of veto, unquote, over the court's decision and the court's power and its decision to authorise this transaction, and whether the member has that power of veto, even though the charity itself asked the court to decide whether the grant is in the interests of the charity. So that's the background. Can I turn to the first main submission, that the Chancellor had power to decide the question of whether this grant is in the interests of the charity, particularly as he was asked to do so. What the Chancellor held, and there's no dispute about it in this court, was that the charity had surrendered to the court its discretion in relation to the making of the grant. The Chancellor explained his reasoning at paragraph 69 of the judgment, which is Appendix Tab 4, MS 275. And Dr. Lehtimaki accepts, rightly in our submission, that because the charity had surrendered its discretion to the court as to whether or not to make this grant, therefore the court, the Chancellor, had power to decide whether the grant is in the interests of the charity. Can I show...
Lord Panic, you've said that at 69 the Chancellor said the charity had surrendered its discretion. I think, to be specific, he says the trustees surrendered theirs. Might there be a difference?
No, because the position was that the charity had itself dealt with the matter by applying to the Charity Commission for permission to make the grant, and the charity itself was the applicant in the proceedings. If your Lordship would go to tab 23 of the appendix, your Lordship will see at MS 447 that it's the charity that is authorised to take these proceedings, and it brought the proceedings seeking approval for the grant. Right, that's what was said. But there's no dispute that the charity had adopted the position of the independent trustees, and it had approved the making of the grant, subject to the views of the Commission or the Court. The position of Dr. Lehtimaki in his written case at MS 111, if I could invite the Court to look at that, the first respondent's written case. At 111, paragraph 2 of Dr. Lehtimaki's written case, he says there are 3 instances where the courts do have jurisdiction to intervene, and over the page, the third of them, MS 112, is where the trustees request the court's intervention by surrendering their discretion to the court, asking the court to approve a particularly momentous decision, or asking the court to approve a potential breach of trust in which the beneficiaries acquiesce. And Dr. Lehtimaki returns to that in his written case at paragraphs 78 through to 80, where he says this is such a case. Dr. Lehtimaki's point being that he, as the member, did not surrender his discretion to the court. And of course I will come to that point.
There are 3 discretions. There's the discretion of the company itself as to whether to make or not make the grant. The discretion of the company's directors, rather confusingly and unhelpfully called trustees, and whether or not to procure that the company takes that step, and the discretion of the member whether to approve it under Section 317. The first 2 can be I think you do say the first 2 can be amalgamated because it's the directors who, under the company's constitution, not the members, decide whether the company should make the grant or not.
Indeed.
Or go to the Charity Commission for permission to make the grant.
Indeed. The point that's taken against us is simply, but importantly, that the member did not surrender whatever discretion he had in relation to approval of the grant. And that I need to deal with. But what I'm focusing on as the first point is I say there is really no dispute that the Chancellor had power in the circumstances of this case to decide whether or not this grant was or was not in the best interests of the charity. And he had that power, as Dr. Lehtimaki accepts, because the trustees who represent the charity asked him to decide that point. And if authority is needed for the proposition that the court has power to decide a matter where the trustees have surrendered discretion to the court, it's found in the case that is cited by the Chancellor at paragraph 64 to 68 of his judgment. It's the authority in volume 5 of the material. It's volume 5, tab 80, MS 2291, and it's the judgment of Mr. Justice Hart, who cites with approval an unreported judgment of Mr. Justice Robert Walker. The background to the case doesn't matter, but on MS 2292, the court will see just below letter E, submission from Mr. Herbert, applications for directions by trustees are a commonplace phenomenon. The ability of trustees to make applications derives from the peculiar relationship of trusts to the Court of Chancery and is no doubt founded in the jurisdiction of this court in an appropriate case itself to execute a trust. Such applications have generally been heard in chambers, and there are consequently few reported cases in which the nature of the jurisdiction has called for detailed analysis. And that's a feature of this area of the law. There are very few unreported cases for the reason that is given by Mr. Justice Hart. And then his lordship cited at G an unreported judgment of Mr. Justice Robert Walker, as he then was. And the relevant part is at 2293, at letter F, subparagraph 3. The third category of case is that of surrender of discretion, properly so called. There, the court will only accept a surrender of discretion for a good reason, the most obvious good reasons being either that the trustees are deadlocked, but honestly deadlocked, or because the trustees are disabled as a result of a conflict of interest. Cases within categories 2 and 3, and he sets out 2 at letter C, are similar in that they're both domestic proceedings traditionally heard in chambers in which adversarial argument is not essential, although it sometimes occurs. It may be that ultimately all will agree on some particular course of action, or at any rate will not violently oppose some particular course of action. The difference is as to whether the court is approving the exercise of discretion by trustees or under category 3 exercising its own discretion. And the Chancellor decided here he was exercising his own discretion.
This applies only by analogy, because here we're talking about a simple trust, as I understand it, public trustee in Cooper.
Yes,
There's no corporate involvement in this.
No, absolutely not. But as by analogy, it must, as has been accepted by Dr. Lehtimaki, be open to the trustees of this corporation to apply to the court for approval of what they propose to do. That's simply not been in dispute.
Well, it may not be in dispute, but it's pretty critical.
Well, it's in my submission, it must be open to the charity trustees to seek the approval of the court in relation to a controversial matter that has exercised them and the charitable corporation in order to resolve a difficult problem.
Calling them trustees absolutely elides the distinction between the company as the quasi-trustee, which has which is the charity which is fulfilling its charitable objects in relation to its property, and the directors of the company. One can think of, it would normally be a question of company law, the extent to which directors of a company can come to court and surrender their discretion about the conduct of the affairs of the company, but a question of trust law about whether the company itself could surrender its discretion, where it is, by analogy, working like charitable trustees.
Yes. Well, that's the other complication here. This is a charitable corporation. And in relation to a charity that takes the form of a corporation, again, in our submission, when one looks at the charitable dimension of this, it would be surprising indeed if the court did not have jurisdiction to give a judgment in relation to the desirability or not of a substantial grant that is being made.
Irrespective of whether or not the relevant member agreed to that application?
Well, in my submission, the member did not oppose the matter going to the court. His position was that at the end of the process, his approval by reason of Section 217 and otherwise was required. But there was no suggestion by him at any stage that this matter was not properly before the court. He didn't say, I disapprove of this agreement, I disapprove of the actions of the trustees in putting the matter before the Charity Commission. I disagree with the attitude of the Charity Commission of putting the matter before the court. At no stage has that occurred, and as I've shown...
But anyway, did he have the power to disapprove? The members' powers in this constitution are quite limited, as I understand it.
Your Lordship...
Which body had the power to procure that the company bring this matter to the court?
Well, but he certainly had power to say to the court, you have no jurisdiction, certainly to make that submission.
But I'm simply asking the company constitutional question. Who was it, the directors or the members, who authorised under the company's constitution to decide whether the company brings this question before the court?
Well, in my submission, given that it's a charitable corporation, it must be open to the directors, the trustees, to ask the court in the interests of charity, is this a desirable grant to make? That is the important feature, an important feature of this case, that the court has its parens patriae jurisdiction in relation to charity. But I've made the point, the court has the point, that it has been no part of the submissions of any of the parties in this court, or indeed in the Court of Appeal, to dispute that the Chancellor had a power, the matter having been referred to him, to make a decision as to what is in the interests of charity. The issue has been whether that is binding on the member, whether it obliges the member to comply with the direction that the court took. So we say...
Isn't that also a company constitutional question of looking at the relationship of the member to the company?
Oh, indeed it is, and that's what I'm coming on to, and I'm going to submit in relation to the second part of my submissions that the reality of the matter is that the member is a part of the administration of the company, and or, if necessary, he has fiduciary responsibilities. And once the court has made its decision on what is in the interests of the charity, he cannot say, well, I take a different view.
Because he's bound by the memorandum and articles to the same extent that the company is.
Indeed, indeed. But that's the second question. The first question, I'm suggesting to the court that the Chancellor had jurisdiction, whether under public trustee in Cooper or by analogy with it. And we say that it is a fortiori, given that this corporation is a charitable corporation. It exists only for charitable purposes. If we look at the Charities Act, which is in volume 1 of the authorities, at tab number 2, this will be very familiar to the court. The court sees at MS 465 the definition of a charity. For the purposes of the law of England and Wales, charity means an institution which is established for charitable purposes only and falls to be subject to the control of the High Court in the exercise of its jurisdiction with respect to charities. An institution, the word that's used in section 1, is defined in section 9, which appears on MS 475, section 9, subsection 3. In this act, institution means an institution whether incorporated or not, and includes a trust or undertaking. And we draw attention to the observations of leading judges on the nature of the role of the court in relation to a charity. The first of those that I wish to mention is in tab 14 of the same bundle, volume 1, and it's at MS 751, the judgment of the Court of Appeal in Gaudia Mission and Brachmachery, and the relevant passage is in the judgment of Lord Justice Mummery at page 350 of the law report, page 760 of the MS. Lord Justice Mummery, of course, had been counsel to the Attorney General in charity matters, and at page 350, just above letter E, his lordship says, under English law, charity has always received special treatment. It often takes the form of a trust, but it's a public trust for the promotion of purposes beneficial to the community, not a trust for private individuals. It's therefore subject to special rules governing registration, administration, taxation, and duration. Although not a state institution, a charity is subject to the constitutional protection of the Crown as parens patriae, acting through the Attorney General, to the state supervision of the charity commissioners, and to the judicial supervision of the High Court. This regime applies whether the charity takes the form of a trust or of an incorporated body. So it's a special jurisdiction, parens patriae, which of course we see in other areas of the law. Wardship is an example, but there are other areas of the law. The court has a special responsibility, jurisdiction. Lord Justice Mummery's predecessor as counsel to the Attorney General was Lord Justice Morritt, and his lordship agreed with Lord Justice Mummery at 355G. The third judge was Lord Justice Leggett, who made some critical comments about the deputy judge and then also agreed in that case. The nature of the charity jurisdiction of the court was also the subject of an observation in the appellate committee by Lord Simons, Lord Chancellor, in volume 4 of the authorities, tab 74, MS 2153. This is the case, well-known case of Gilmore and Coates, and it's a short observation by Lord Simons at the bottom of page 448 of the report, page 2175, MS 2175. And what Lord Simons says, and we commend it to the court, it is a trite saying that the law is life, not logic. That's Oliver Wendell Holmes. But it is, I think, conspicuously true of the law of charity. It's been built up not logically, but empirically. And the reason for that, in my submission, is because the court is seeking to protect the public benefit in charity. And that very much depends upon the circumstances of the particular case. We also draw attention to the judgments of the Court of Appeal in the construction industry case, which the court will find in volume 1 of the authorities behind tab number 12, MS 707. And in this case, the issue was whether the provisions of the Industrial Training Act ousted the jurisdiction of the court in relation to the charity. And the court was divided on that issue, the majority concluding the Act had not ousted the jurisdiction of the court. Lord Justice Russell dissented. Lord Justice Buckley, who was also a former counsel for the Attorney General on charity law, addressed the nature of the jurisdiction at 186, which is MS 720. And at 186, just under letter D, his lordship says it is a function of the Crown as parens patriae to ensure the due administration of established charities and the proper application of funds devoted to charitable purposes. This it normally does through the instrumentality of the courts. But that's not the only way in which the Crown can regulate charities or the application of charitable funds. And then his lordship refers to Royal Charter, where funds are given for charitable purposes in circumstances in which no express or implied trust is created. The Crown can regulate the application of the funds by means of a scheme under the sign manual. Where the Crown invokes the assistance of the courts for such purposes, the jurisdiction which is invoked is, I think, a branch of the court's jurisdiction in relation to trusts. In such cases, the relief granted often takes the form of an order approving a scheme for the administration of the charity which has been laid before the court. But this is not the only way in which the court can exercise jurisdiction in respect of a charity or over charity trustees. The approval of a scheme of this nature, so far as I'm aware, says his lordship, a form of relief peculiar to charities, but it does not constitute relief of a kind given in the exercise of a jurisdiction confined to giving relief of that sort. The court could, for instance, restrain trustees from applying charitable funds in breach of trust by means of an injunction. In the case of a charity incorporated by statute, this might, as was suggested, be explained as an application of ultra vires, but that's not a satisfactory explanation, for a similar order upon unincorporated trustees could not be so explained. A further example, the court could order charity trustees to make good trust funds they've misapplied, or could order them to account, or could remove or appoint trustees, or could exercise any other kind of jurisdiction available in the execution of trusts other than charitable trusts. In every such case, the court would be acting upon the basis that the property affected is not in the beneficial ownership of the persons or body in whom its legal ownership is vested, but is devoted to charitable purposes. That is to say, is held upon charitable trust, and that point we emphasise. Any relief...
But both those extra examples beyond scheme, one is breach of trust,
Yes.
two is misapplication,
Yes.
doesn't go far enough for you.
Well, they're examples, my lord. They're examples of a principle. In every such case, the court would be acting upon the basis that the property affected is not in the beneficial ownership of the persons or body in whom its legal ownership is vested, but is devoted to charitable purposes. That is to say, is held upon charitable trust. So the principle, in my submission, the principle is that the court has power to do what it regards as appropriate to address the public interest. And in any event, I will submit, and I'll come to this point, if one needs a scheme, the concept of a scheme doesn't depend upon some formality. One could, if necessary, describe the judgment of the Chancellor as approving this substantial transaction as a scheme. It's a written instrument which is designed to address what the Chancellor regarded as a serious problem in the administration of this charitable corporation. But I'll come to that if I may. But I take your Lordship's point. But I say what Lord Justice Buckley, with his experience, is doing is setting out the nature of the jurisdiction of the court. And one also sees to similar effect Lord Justice Russell, albeit he's dissenting on the particular circumstances of the case, that he too deals with the nature of the jurisdiction. And it's at 184, my Lord, 184b, on the whole, this is MS 718, on the whole, says Lord Justice Russell, I consider that the reference in the definition to the control of the court, and that's a reference to the statutory provision, which was section 45(1) of the Charities Act 1960. Your Lordships, your Ladyships see that if the court turns back to page 180 of the report at letter B. Now, this is Lord Justice Russell at 180 letter B. Now it was argued before us for the board that the function, or at least a main function, of the words in section 45(1) of the Act of 1960, and is subject to the control of the court in the exercise of the court's jurisdiction with respect to charities, is one of territorial limitation. And that's what Lord Justice Russell is addressing at 184b. On the whole, I consider, he says, his Lordship says, that the reference in the definition to the control of the court in the exercise of the stated jurisdiction is designed to point to a charitable institution in respect of which the court has power generally to supervise and direct the administration, to supply any defects in the regulations when such are revealed, to remove and appoint where necessary for the due administration of the institution trustees or governors, to make orders where necessary for that due administration as to vesting and otherwise of assets of the institution, and to make schemes for the CPRE application of assets.
So do I understand your submission that the court has jurisdiction to go so far as necessary? It won't go further than necessary, and insofar as there may be some discretion left in the trustees, the court having exercised that jurisdiction, so be it. But you say the court has jurisdiction to go so far as necessary to solve the particular problem.
Well, I would, if I need to, go even further than that. I would say that the jurisdiction of the court is to do what it regards as expedient. So I wouldn't wish to be confined to a test of necessity. I would respectfully submit that the court, in relation to a charity, has the responsibility of deciding what is in the public interest. Now, it is true that in many contexts the court would be slow to substitute its view for that of the trustees. I'm not suggesting to the court that the judge would necessarily wish to exercise jurisdiction, but he or she has a very broad discretion, and the reason for that is because the courts, with the assistance of the Crown, with the assistance of the Attorney General, has a parens patriae jurisdiction over the interests of charity. There are no private interests, there's no private property. It is property held in the public interest for the public benefit. And we say that the two authorities that I have cited support that approach. And indeed, it is long established that the court has a general jurisdiction to approve or disapprove of the disposal of the property of a charity. We draw attention, for example, to the authority that the court will find in volume 5 of the authorities at tab 82, MS 2305. And it's a happily short report of a decision of the Master of the Rolls, Sir John Romilly, in a case called Re Ashton Charity, 1856. And in the middle of the page, Your Ladyship, Your Lordship, see the Master of the Rolls, Sir John Romilly, says this: I have before had to consider this point. My opinion is that upon an information, the Court of Chancery has a general jurisdiction as incident to the administration of a charity estate to alien charity property, where it clearly sees it is for its, that's the charity's, benefit and advantage. I think that this power may also be exercised under the statute, and if one looks higher up, one can see that the statute was the Sir Samuel Romilly's Act, father of the Master of the Rolls. But it's not put on the basis of a statutory jurisdiction, it's the general jurisdiction of the Court of Chancery in performance of its responsibilities in relation to charity. And that authority is the subject of some modern consideration. It was looked at in the case of Oldham and the Attorney General, which is in volume 1 of the authorities, behind tab 24, which is MS 987. Oldham Borough Council and Attorney General. And I cite this simply because Lord Justice Dillon, speaking for the Court of Appeal at page 222 of the report, MS 999, at the top of the page, the court sees in the second line the case I've just cited was mentioned, Re Ashton Charity, and it's summarised. And then just under, well, between B and C, other cases where the court decreed a sale of charity lands otherwise than by way of CPRE scheme, because the court was satisfied the sale of those lands would be beneficial to the charity, are, and then a number of cases are mentioned. This seems to have been standard practice in the 19th century. I see no reason why Parliament should have intended to alter it. So there is authority for the proposition that in relation to the disposal of charity property, the court does have, as part of its function in relation to the administration of charities, the protection of the public interest, it has this very broad jurisdiction to decide what is in the interests of the charity. There are also, and my Lord Wilson mentioned this, there are the scheme cases. And an example of the breadth of the jurisdiction that the court enjoys in relation to a charity to make a scheme can be found in volume 2 of the authorities. Behind tab 30, MS 1221, and this was a judgment by Mr. Justice Peter Gibson, and it concerned an application to remove a provision from the trust requiring a fund to be distributed within 10 years after the settler's death. That was the issue. And the application was brought on 2 bases. First, by reference to the court's CPRE jurisdiction. Could the court vary the terms? And that failed because the 10-year rule was not part of the objects of the trust. That's at page 153, C to D, and I won't focus on that. But what the court did decide positively was that it could exercise its inherent jurisdiction over the charitable trust to approve this modification. And if the court please would turn to page 146 of the report, MS 1224, the court sees the argument advanced on behalf of the Attorney General by Mr. Christopher McCall, and his submission was the court has unlimited jurisdiction to regulate the administration of a charity, which jurisdiction depends neither on statute nor the CPRE rule. That was the submission made on behalf of the Attorney General. And at page 153 of the report, page MS 1231, letter E, at the end of that paragraph, page 153, letter E, His Lordship says that the next question is whether the court under its inherent jurisdiction should direct the removal of the requirement as to distribution. That's the 10-year rule. To that question I now turn. On this question, Mr. Picarda, who appeared for the trustees, and Mr. McCall submit, and I accept that the court is not fettered by the particular conditions imposed by section 13(1)(e)(3) of the Act, and that the court can find, if the court wants to look at it, at page 148, letter H, but can and should take into account all the circumstances of the charity, including how the charity has been distributing its money, in considering whether it is expedient, and that's why I gave the answer I did to my Lord Kitchen, whether it is expedient to regulate the administration of the charity by removing the requirements to distribution within 10 years of the settler's death. And at 155, letter C, His Lordship said that the plaintiff had made out a very powerful case for the removal of the requirement as to distribution, which seems to His Lordship to be inexpedient in the very altered circumstances of the charity since that requirement was laid down 60 years ago. I take particular account of the fact that this application is one that has the support of the Attorney General. My submission, the court's not bound by the views of the Attorney General, but plainly, in a charity context, the views of the Attorney General as to whether a proposal is in the interests of charity is a very material circumstance for the court to take into account. Then his lordship gives a bit more detail about that. And at the end, at D, I have no hesitation in reaching the conclusion the court should, in the exercise of its inherent jurisdiction, approve a scheme under which the trustees for the time being will be discharged from the obligation to distribute the capital within 10 years of the death of the settler. Now, it is true that this is a case about a scheme. I of course, accept that, but Lord Justice Buckley, in the Construction Board case, said that the powers of the court are not confined to the making of a scheme. That was MS 720, page 186, F to G. And if it matters, if it really matters, we say that a scheme is simply an order of the court which approves an arrangement. And the Chancellor's order in this case, it's Appendix Tab 3, MS 248, approved that the management and administration of the $360 million of SIF's property should in future be undertaken by the new charity, BWP. It should be transferred.
I confess, Lord Planning, I obviously haven't read your case sufficiently. I didn't realise you were saying this was a scheme case.
If necessary, if it really matters, if it is accepted and appears to be accepted, that the court does have power to make a scheme in relation to a problem in a charity. It can address a problem by making a scheme where the court thinks it expedient to do so. Then I say, what is it about this arrangement in relation to a very substantial sum of money where the Chancellor has perceived, and no one challenges the Chancellor's perception, that there is a real problem in the administration of this charity which needs to be addressed? I say that the decision of the Chancellor, his order, if necessary, can be described as a scheme. It's an approval of an arrangement subject to the conditions set out by the Chancellor. Now, the Court of Appeal referred, it was paragraph 54 of its judgment, MS 241, to another judgment of Lord Walker for the Hong Kong Court of Appeal in the Chinachem Charitable Foundation case. And the court will wish to look at that. It can be found in volume 3 of the authorities, behind tab 36. Chinachem, and it's MS 1315. And it's the judgment of the Court of Final Appeal of Hong Kong given by Lord Walker, and the relevant passage the court will find at MS 1325, paragraph 41, my lords, my lady. And what Lord Walker says...
So sorry, did you say MS 1325?
1325, my lord.
Thank you.
And it's paragraph 41. The court has an inherent jurisdiction over the administration of charitable trusts, originally based on the notion of the sovereign as parens patriae, parent of the nation. This jurisdiction could be invoked by the Attorney General, in Hong Kong the Secretary for Justice, as the sovereign's forensic representative. Where the court exercises its jurisdiction to clarify or modify the purposes of a charitable trust, or to improve the administration of a charitable trust, it does so by making a scheme. That is a written instrument approved by the court to regulate, in whole or in part, the future management and administration of the trust. And that's what we have here. We have an order of the court, a written instrument, in which His Lordship the Chancellor has regulated, in part, the future management and administration of the trust, the charitable corporation. He's regulated the disposal of £360 million of the fund. I say Lord Walker was referring to a scheme in the broadest possible terms, and that is entirely consistent with the other authorities that I've shown the court from Sir John Romilly's case onwards. At paragraphs 50 and 61 of its judgment, the Court of Appeal referred to Lord Truro's dictum in Re Beloved Wilkes charity, and the court will wish to look at that. It's in the Bundles of Authorities, Volume 2, tab 28, and it's MS 1205. And this is Lord Chancellor Truro in 1851. And if the court has MS 1208, your ladyship and your lordships will see the relevant passage of the judgment on MS 1208, some 12 lines up from the bottom of the page, just after the new page number 448. His Lordship says, without occupying time by going into a lengthened examination of the decisions, the result of them appears to me so clear and reasonable that it will be sufficient to state my conclusion in point of law to be that in such cases as I've mentioned, it is to the discretion of the trustees that the execution of the trust is confided, that discretion being exercised with an entire absence of indirect motive, with honesty of intention, and with a fair consideration of the subject. The duty of supervision on the part of this court will thus be confined to the question of the honesty, integrity, and fairness with which the deliberation has been conducted, and will not be extended to the accuracy of the conclusion arrived at, in these words, except in particular cases. If, however, as stated by Lord Ellenborough, trustees think fit to state a reason, and the reason is one which does not justify their conclusion, then the court may say they've acted by mistake and in error, and that it will correct their decision. And that was relied on by the Court of Appeal. They said, well, it follows from that the court has no power to give directions unless there's some bad faith or some fundamental error, something of that. So we don't accept that with great respect. Lord Truro was very careful to say, except in particular cases, and he went on to state that if a reason is given, then the court can say whether it's right or wrong. So we don't accept this is a limiting a principle. We say the principle is that it all depends. All depends on the circumstances of the particular case, what the court will do. We recognise, of course, that the court may be reluctant to interfere or to intervene, to use a non-pejorative term, in the circumstances of particular cases. But here, as I've said, the trustees on behalf of the charity did ask the Chancellor to determine the matter, and he formed a very clear view. So we don't accept that authority in any way limits the powers of the court. Reliance is placed by my friends on cases concerning private trusts and the circumstances in which the court will intervene in relation to decisions of the trustees of private trusts. And the submission that's made against me is that the court will not normally substitute its discretion for that of trustees acting in good faith and reasonably. I say a number of things in answer to that. First of all, private trusts, of course, are not subject to the parens patriae jurisdiction of the court. Private trust, by definition, is concerned with private property interests. A trust that is a charitable trust or charitable corporation is concerned with objects which are exclusively charitable and in respect to which the court has, as I submit, the jurisdiction for which we contend, assisted by the Attorney General, to protect the public interest. And the cases that I have cited in my submission support that submission. That's the first point. The second point I've made already, the present case is a case where the trustees, on behalf of the charitable corporation, have surrendered their discretion to the court and have asked the court to decide whether this grant is in the interests of charity or not. And the court has determined that issue, just as it did in the Ashton case and many other cases. The third point that we is that in any event, and I don't need to go this far, but in any event, even in the context of private, non-charitable trusts, there are circumstances where the court has exercised a broad jurisdiction to intervene to secure the more effective administration of the trust property for the benefit of the beneficiaries. And an example of that is the court's inherent jurisdiction to remove a trustee from office, which power is not dependent, in my submission, on the ability of those seeking the intervention of the court to show any wrongdoing or threatened future wrongdoing on the part of the trustee. And the case that we draw to the attention of the court to that effect is Lehtimaki and Browers, which is volume 1 of the authorities. It's tab 19. And it's MS 811. And this is the advice for the board of Lord Blackburn, MS 811, tab 19 of volume 1. The head note summarises what Lord Blackburn says. There is a jurisdiction in courts of equity to remove old trustees and substitute new ones in cases requiring such a remedy. The main principle on which such jurisdiction should be exercised is the welfare of the beneficiaries and of the trust estate. And Lord Blackburn says that at page 387, at the top of the page, it's MS 827, the first new paragraph on page 387, Lord Blackburn says, in exercising so delicate a jurisdiction as that of removing trustees, their lordships do not venture to lay down any general rule beyond the very broad principle above enunciated that their main guide must be the welfare of the beneficiaries. Probably it is not possible to lay down any more definite rule in a matter so essentially dependent on details, often of great nicety, but they proceed to look carefully into the circumstances of the case. In other words, everything depends upon the facts. And that chimes, in my submission, a fortiori with the position in relation to charity, both because charity, the court's role is to protect the public interest, the parens patriae jurisdiction, and because of the dictum of Lord Simmons from Gilmore and Coates that I cited, that in the context of charity, the law is looking at experience, it's seeking to respond to the particular circumstances of particular cases. Now, my friend says, Dr. Lehtimaki in particular, on his behalf, it is said that the Privy Council in that case, Letterstedt and Brewers, had strong grounds on the facts for removing the trustees. No doubt. The point I make is that the principle that is articulated by Lord Blackburn is a very general principle, and we say, therefore, that the reliance on private trusts, even if one ignores the distinctions that there are, because private trusts are for private property interests, in any event, my friends put their case far too high in suggesting that the court would only have power to intervene if there is some bad faith or manifest unreasonableness or something of that sort. Can I also draw attention, since this authority is before the court, to what is said by Lord Blackburn on the preceding page, page 386, MS 826, in the middle of the page, the new paragraph in the middle of the page. The reason why there is so little to be found in the books on this subject is probably that suggested by Mr. Davey in his argument. And then if the court travels down to about 8 lines from the end of that page, cases involving the necessity of deciding this, if they ever arise, do so without getting reported. And I draw attention to that, as I did to the observation of Mr. Justice Hart in the public trustee case, because one of the points that is made, I think by Mr. Crowe on behalf of Sir Christopher Hone, is that we can't point to specific cases that are analogous to the present one. And my submission is there is a paucity of authority in this area. I've shown the court what we say are the relevant authorities and why we say they are sufficient, but it really isn't a powerful point in the light of that and Mr. Justice Hart's modern statement to say, well, you can't point to a specific case that covers this particular ground. It's the principles in my submission that matter. And so we submit, and this is our first proposition, that the court, especially when asked to do so by the trustees on behalf of the charity, does have power to decide whether this specific transaction is in the interests of the charity. And it has power by reason of its inherent jurisdiction and the surrender of the discretion to the court to give directions, subject to what I'm coming on to. Can it give directions to the member who was not party to the surrender? But that's what I wanted to say on the first issue. I'm coming on to the particular position of Dr. Lehtimaki. My second submission then is that in exercising the jurisdiction which we contend that the court has, we say that the court was entitled to regard Dr. Lehtimaki as part of the administration of the charity, whose trustees on its behalf had sought the judgment of the court. We will submit that the member has duties to advance and protect the interests of the charity, but he has no relevant personal interest. And we say if the court were to lack power to give a direction to the member in such circumstances, the court's ability to perform its important role of protecting and advancing the public interest in the charity in relation to the question put to it, and which it has determined, would be significantly undermined. And that would, in my submission, be contrary to the whole basis of the parens patriae jurisdiction. Now, can I show the court what the Court of Appeal did accept? If the court, please, would go to Appendix tab 2, MS 238. This is the appendix, not the authorities, the appendix, tab 2. The court finds the judgment of the Court of Appeal. And at MS 238, paragraph 45, the Court of Appeal said this, in all the circumstances, MS 238, in all the circumstances, we agree with the Chancellor that members of SIF owe fiduciary duties. It seems to us that contrary to Mr. Ham's submissions, members do not sit outside the company, but are, as the Chancellor said, part of the administration of the charity, with powers that are all directed at aspects of the management and administration of the charity designed to achieve the charity's exclusively charitable objects. And the relevant paragraphs of the Chancellor's judgment, I won't take the court to them, but they're there referred to, paragraphs 141 and 145, which is tab 4, MS 293 to 294. And we say that conclusion, with respect, is plainly correct. And we ask the court to look at the memorandum and the articles of association of this charity. The memorandum appears in the core volume at tab number 21, beginning at MS 215. And at MS 216, the objects of the charity are set out. That the objects of the charity are the general purposes of such charitable bodies or for such other purposes for the benefit of the community.
Sorry, Mr. Lehtimaki,
I'm sorry,
something's gone wrong with the
433.
numbering.
I'm sorry, 432. I'm using the wrong numbering. 432 and 433.
Thank you.
I'm grateful. 433 sets out the objects behind tab 21. The objects of the charity are the general purposes of such charitable bodies or for such other purposes for the benefit of the community as shall be exclusively charitable, as the trustees may from time to time determine. And clause 5.1 on MS 435, 5.1, the property and funds of the charity must be used only for promoting the objects and do not belong to the members of the charity, but then there are some exceptions there set out. Members who are not trustees may be employed, for example, and at 514, individual members who are not trustees but who are beneficiaries may receive charitable benefits in that capacity. So it's as recipients of charity.
Shall we, should we note, while we're going through this, paragraph 413? Is that relevant?
Paragraph 413, yes, thank you, my lord. The powers include powers to make grants or loans of money and to give guarantees. And this is a grant-making charity. Clause 8 on page MS 437 deals with dissolution. And paragraph 8.1, if the charity is dissolved, the assets, if any, remaining after provision has been made for all its liabilities must be applied in one or more of the following ways: by transfer to one or more other bodies established for exclusively charitable purposes within the same or similar to the objects, directly for the objects or charitable purposes within or similar to the objects, or in such other manner consistent with charitable status as the Commission approve in writing in advance. And plainly, it can't go to the members, unless they are recipients of charity, but it can only be dissolution. The assets, if any, have to be used for charitable purposes, and indeed, if that were not the case, it wouldn't be a charitable purpose. It wouldn't be for charitable purposes. So that's the
That particular restriction reflects a requirement which goes back to the 1862 Act.
Indeed.
And so it would seem to suggest that Parliament took the view that the court would have jurisdiction to enforce that provision, perhaps having regard to authorities like Ashton in 1856.
Well, I'm grateful to your ladyship. Yes, I respectfully agree. Tab 22 contains the articles of association. Can I again...
I wonder, Lord Penick, just while we have the memorandum,
Yes, of course.
is this a useful moment to look at 5.2?
5.2, a trustee must not receive any payment of money or other material benefit, whether directly or indirectly from the charity, except, and there's a number of exceptions, and 5.25, in exceptional cases, other payments or benefits, but only with the written approval of the Commission in advance. And the Chancellor, this may be the point the Lordship's adverting to, the Chancellor held that there were two reasons why the approval of the Commission, and therefore the Court, when the Commission transferred the question to the Court, why approval was needed in this case. It wasn't simply Section 217, it was also Clause 5.2.5. That may be the point your Lordship had in mind.
The force of this is really operating to give liberty to take certain expenses.
Yes.
Rather than as a restriction. There is the general law saying that trustees may not take benefits, but this gives
the
them...
memorandum has expressly addressed this as well. So that's the memorandum. The Articles of Association, pick out, there may be others, but pick out particularly relevant provisions. 1.5 on, it's the next tab, it's tab 22, and it's MS 439. 1.5 deals with when membership, well, 1.3 deals with to whom membership is open, and 1.5 deals with the termination of membership. Membership is terminated if the member concerned gives written notice, dies, he or she's in arrears, and 1.5.4 is removed from membership by resolution of the trustees on the ground that in their reasonable opinion the member's continued membership is harmful to the charity, but only after notifying the member in writing and considering the matter in the light of any written representations which the member concerned puts forward. So again, as a matter of substance, again, it makes clear, consistent with everything else that we've seen, that the member's responsibilities are to act in the interests of the charity. And there are other provisions which I don't think I need to read out, but I'm happy to comment on if your ladyships wish me to do so. That's what I wanted to.
It would help just to have, but don't do it now, the provisions in the articles that, if they do, confer on the directors, who we keep calling the trustees, the power to refer matters to the court or to decide questions or run the charity. In other words,
I don't think there's an. I'm not aware. Mr. Taub will tell me if I'm wrong.
well, I'm not suggesting they do so expressly, but it's part of your case that the directors were properly authorised to bring before the court for decision the question whether the transaction was in the interests of the charity, and therefore that authority must come from somewhere, presumably in the articles.
Yes.
Yeah.
Yes, 3.1,
Yes.
I'm grateful. At MS 441, the trustees as charity trustees have control of the charity and its property and funds.
Perhaps also 6.8.
Yes, 6.8 as well. Paragraph 6 is powers of trustees. 6.8, they have a power to exercise any powers of the charity which are not reserved to a general meeting. We'll see if we can find any others, but those are the ones that are relevant. Now, we say that, and I've shown the passage in the Court of Appeal judgment, we say the Chancellor and the Court of Appeal were correct to conclude that the governing instruments show that SIF's members are parts of the administrative machinery of the company. In terms of the charity as an institution, that's the term used in section 1 that I showed the court of the Charities Act, they are parts of the institution. And the question arises, therefore, as to whether Dr. Lehtimaki is correct to say, and as he persuaded the Court of Appeal, that the court cannot order him to vote in favour of the grant. The court has no power to give him directions because he had not surrendered his powers to the court. And our submission is that if I'm right in my first submission, that the court did have power, as has not hitherto been disputed, the court had a general power to decide what is in the interests of this charity, and in particular whether this grant is in the interests of this charity. The court, in my submission, must have power, particularly in a charitable context, given its parens patriae jurisdiction. It must have power to give a direction to a person who is part of the administration of the charity, who has no personal interest to protect. I say once the court has been asked to decide this question, is this grant in the interests of the charity? And once it's decided that question in the affirmative, the court must have power to prevent the member answering the same question in a different manner that is contrary to the conclusion that the court has reached. Now, if necessary, I also submit that the Court of Appeal was correct to find, and I've shown this court the passage, paragraph 45 of the judgment, but also paragraphs 38 to 39. The Court of Appeal was correct to find, again agreeing with the Chancellor, that members of SIF owe fiduciary duties in the present context. That is, in relation to the exercise of their power, whether to approve this grant. And perhaps we could just look again at the Court of Appeal. There's another passage that I would ask the court to look at. It's in the whole volume, in the appendix tab 2, at page 235. Paragraph 36 of the judgment.
Got a MS number.
MS 235.
Thank you.
MS 235, it's paragraph 36, where the Court of Appeal say, on the other hand, membership of a charitable company limited by guarantee is very different from ownership of shares in a non-charitable company. Company cannot be charitable without being established for charitable purposes only. its assets will be devoted exclusively to charitable purposes, not the private interests of its members. While therefore a share is property and the right to vote attached to it an incident of property to be enjoyed and exercised for the owner's personal advantage, membership of a charitable company confers no proprietary rights. It brings with it not property, but functions in connection with assets appropriated to charity, in which the member has no personal stake. And then there's a reference to the provisions in the instruments of this charity. The Court of Appeal then referred to the authorities on fiduciary status. Can I just mention two of them? The first is Lord Millett's judgment in Bristol and West Building Society in Mothew, which is volume 1 of the authorities, tab 10 at MS 633. And the relevant passage in the judgment of Lord Justice Millett for the court appears at MS 650, page 18 of the report, just under letter A. Fourth line on page 18, a fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. The core liability has several facets. A fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interests may conflict. He may not act for his own benefit or the benefit of a third person without the informed consent of his principal. This is not intended to be an exhaustive list, but it's sufficient to indicate the nature of fiduciary obligations. They are the defining characteristics of the fiduciary. As Dr. Finn pointed out in his classic work, Fiduciary Obligations, he is not subject to fiduciary obligations because he is a fiduciary. It is because he is subject to them that he is a fiduciary. And we respectfully adopt all of that. So more important than the label is the substance of the obligations that are imposed on the individual. The Court of Appeal also referred to the judgment of Mr. Justice Finn, as Professor Finn had by that stage become. He said, incidentally, on his appointment to the Federal Court that he'd not been in a courtroom for 25 years. He gave judgment in Grimaldi in the Federal Court of Australia, Appeal Division, which is volume 3 of the authorities. At tab 38, MS 1347, and this case was referred to by the Court of Appeal at paragraph 38 of the judgment, MS 236. So Grimaldi at 1347, the relevant paragraph is paragraph 177, which appears at MS 1396. And his lordship there says, as to who is a fiduciary, there is no generally agreed and unexceptionable definition. The following description suffices for present purposes. A person will be in a fiduciary relationship with another when and in so far as that person has undertaken to perform such a function for or has assumed such a responsibility to another as would thereby reasonably entitle that other to expect that he or she will act in that other's interest to the exclusion of his or her own or a third party's interest. And we say that applies here.
This needs slight adjustment, doesn't it, in relation to a charitable trust or obligation, because this all assumes that there is the other or the principal, as Lord Millick calls him, is the beneficiary. Whereas here we're concerned with, I think, public purposes rather than beneficiaries as such.
Your Lordship is correct. Again, I would say that is a fortiori, that because the responsibility of the member in this context is not to protect any private interest, but to advance the public interest in charity, there being charitable objects, it cannot be the case that the member is entitled to act in his own interests or in the interests of any other individual. Cannot be the case. The member does have, as the Court of Appeal accepted, a responsibility to exercise his functions as a member in the interests of the charity itself. It's a fiduciary obligation because it's an obligation of trust and loyalty towards, as your Lordship points out, the public interest that is the equivalent of the private interests that one finds in relation to private law trusts. Dr. Lehtimaki, in my submission, could not exercise his vote, not lawfully exercise his vote in the present context out of personal antipathy to Miss Cooper, or because he wished to ingratiate himself with Sir Christopher, or for any other personal or private interest of that sort. I'm not making any allegations, but he couldn't. He has to ask himself what is in the interests of the charity.
In Justice Finn's paragraph 177, when he refers to an entitlement on the part of the other party to expect that the putative trustee will act in that person's interest to the exclusion of his own interest, he means in respect of the performance of that function.
Yes.
There could be other functions which that person has, but it is only necessary to find that it is a fiduciary relationship as defined by Mr. Justice Finn in respect of a particular function.
Yes, I entirely agree with your ladyship, and the court, when it determines whether there is a fiduciary relationship, will focus on the particular context that is before it. And it may or may not be that in other contexts, the same person does not owe fiduciary duties. This is context driven, and indeed that was what Mr. Justice Sales, as he then was, said in the F and C case. It's volume 1 of the authorities. Please look at that. Volume 1 of the authorities, tab number 13. Mr. Justice Sales, F and C. This is MS 725, and the relevant passage in the judgment of his lordship it's on MS 732, picking it up at paragraph 222, MS 732, just above letter E. His lordship says, however, there's always been scope for fiduciary duties to be found to arise in a range of other contexts which have important similarities to the paradigm cases, but also significant differences. In those contexts, it is necessary to examine with some care what is the precise content of the particular fiduciary obligations arising in the specific circumstances of the individual case. And his lordship returns to that slightly lower in the page, just under letter G. The touchstone is to ask what obligations of a fiduciary character may reasonably be expected to apply in the particular context. And then he refers to the contract in that case. So I respectfully agree with your ladyship that the question is not whether a particular person is a fiduciary. The question is what duties do they owe of a relevant nature in the particular circumstances of the case, and do those obligations mean that one can accurately describe them as a fiduciary for that purpose?
Indeed. It's particularly important in commercial transactions where somebody may act
Precisely
as a
so.
fiduciary for only limited purposes.
Absolutely. And I'm making no broader submission than that the Chancellor and the Court of Appeal were correct to find that Dr. Lehtimaki is a fiduciary for the purposes of this case, that is, when he asks himself whether or not he should approve as a member this particular transaction. Now, indeed, of course, it's not determinative, far from it, but it is of some interest that it was not in dispute before the Chancellor that Dr. Lehtimaki is acting in a fiduciary capacity in the present context. Dr. Lehtimaki changed his position, as he's entitled to, in the Court of Appeal, where he unsuccessfully disputed that he had a fiduciary status. See the judgment of the Chancellor as to what the submission was before him at paragraph 39 of the judgment, quoting from paragraph 49 of Dr. Lehtimaki's second witness statement, which is at MS3-6, but I won't take time on that. So we say that it's not, if it's necessary to decide whether the member here is a fiduciary, we say that question should be answered in the affirmative, but I've made the submission that one doesn't need to go that far. It's sufficient for our purposes that he is at the very least part of the administration of the charity with duties to perform on its behalf. Sir Christopher gives 5 main reasons in his written case. It's MS 191 paragraph 8. I don't ask the court to turn it up, but that's where the court finds it. 5 main reasons why he says that Dr. Lehtimaki is not a fiduciary. And first of all, he refers to the position under company law in relation to members. Well, we say that that ignores the fact that we are here concerned with a charitable corporation and one which expressly provides that the members have no personal interest to protect. Their only interest is the interest of the charity. His second point, Sir Christopher, is to refer to the fact that the legislation, the Charities Act, does not expressly address this point. And indeed, he draws attention to the fact that there is a new concept created by the Charities Act 2011, the Charitable Incorporated Organisation, which does expressly address the responsibilities of the member. Can I show the court what Sir Christopher is focusing upon? It's in volume 4 of the authorities. The court will find the relevant statutory provisions at tab 53, in particular at page 1757. Section 204 defines, or rather identifies, what a CIO means. It means a charitable incorporated organisation. As the court will know, this is a new corporate form for charities. It has simpler administrative requirements. The charitable company, limited by guarantee, has the disadvantage of double regulation. It's regulated both by Companies House and the Charity Commission. And this new concept, the CIO, has the benefit of its own legal personality, but unlike the traditional charitable company limited by guarantee, it's subject to regulation only by the Charity Commission. That's the advantage of it. And the relevant provision that is relied upon is section 220, which the court finds at MS 1775. And section 220 at MS 1775 is headed Duty of CIO Members, and it says each member of a CIO must exercise the powers that the member has in that capacity in the way that the member decides in good faith would be most likely to further the purposes of the CIO, clearly a fiduciary obligation. And the point that is made is, well, we don't find such a provision in relation to the members of a charitable corporation. To which a part of our answer is that if one turns the page to MS 1776, one sees that these statutory provisions contain the same approach in relation to the duty of charity trustees. Each charity trustee of a CIO must exercise the powers and perform the functions that the charity trustee has in that capacity in the way that the charity trustee decides in good faith would be most likely to further the purposes of the CIO. There's absolutely no doubt that that would be a fiduciary obligation in any event. And my submission is that all we see in sections 220 and 221 is a very sensible, understandable approach by Parliament that when a new concept is being created, it was as well for the avoidance of any possible doubt to specify the fiduciary nature of the obligations, both of the member and the trustees. But it tells the court, in my submission, absolutely nothing as to whether the member of the charitable corporation in this case owes fiduciary duties. And for all the reasons that I have given, the answer in my submission is plainly in the affirmative. And indeed, it's never been the case advanced on behalf of Dr. Lehtimaki that he could take a decision other than in what he regards as being the best interests of the charity. Then Sir Christopher relies on previous case law, which he says suggests that members of a charitable company do not owe fiduciary obligations. And the case that he relies upon is Bolton and Madden. This again is in volume 4 of the authorities. It's at tab 68, MS 2035. It's a judgment of Mr. Justice Blackburn, as he then was. And the case concerned, it's an odd case, it's a case about two subscribers to a charity, the objects of which were chosen by the subscribers. And they had a contractual agreement. They agreed that if one of them gave votes for an object that the other preferred, the other would do likewise. And the former, inevitably, that's why it's in the law reports, one of them performed his obligations and the other one defaulted. And the former brought proceedings to enforce the contractual agreement. And what my friends rely upon is the passage at page 57, MS 2037, the first new paragraph. The argument for the defendant was that the subscriber to a charity is under an obligation to give his votes for the best object, and that the plaintiff, if he gave his votes at the first election to what he thought the best candidate, incurred neither trouble nor prejudice, so that there was, in that point of view, no consideration. And if he gave his votes to the candidate whom he did not think the best, the whole agreement was void, as against public policy. But though some of us, at least, much disapprove of this kind of traffic, we can find no legal principle to justify us in holding that the subscriber to a charity may not give his votes as he pleases, answering only to his own conscience and reputation for the way he exercises his power. It's an odd case, my lords, my lady, because as appears from MS 2035, neither the charity nor the Attorney General was represented. It's dealt with, it's not a case dealing with the court's jurisdiction to protect the interests of charity. So it's a puzzling case, and the explanation for it may well be that there was no question that each of the objects favoured by the rival subscribers was in the interests of charity. That may be the...
It had to be a charity, whichever way they voted.
Indeed.
So it's a,
That may be the explanation.
and what Mr. Justice Blackburn says must be read in that context.
In my submission. And indeed, what Mr. Justice Blackburn said proves too much for Dr. Lehtimaki. The passage that the subscriber, here the member, may give his votes as he pleases, answering only to his own conscience and reputation for the way he exercises power. As I've said, that's never been the submission by Dr. Lehtimaki. He's never suggested that, having regard to the memorandum and the Articles of Association and the responsibilities that he has, that he can decide if it's in accord with his own conscience, having regard to his own reputation, he could decide against this grant because Sir Christopher's asked him to. That's not his case. So it is an odd case. In my submission, it provides no answer to the submissions that we make to the court as to why, on analysis, there is here a fiduciary status. Then Sir Christopher expresses concerns about the practical implications if the court were to accept that a member in the context of this case has a fiduciary obligation. It said that this may deter people from becoming or remaining members of a charitable association. The first answer to that is plainly it has not concerned the Charity Commission. And I'm not talking about this case, I'm talking about the guidance that the Charity Commission has published. If the court, please, would go to volume 6 of the authorities, tab 101, which is MS 2577, the court will find a document guidance published by the Charity Commission. We have the 2004 version, so it's not a new document. It's called RS7, Membership Charities. And I draw attention to two passages. The first of them is at MS 2597. In the left-hand column at MS 2597, it's page 18 of the document, 2597, left-hand column in the middle of the page by the bullet points. First bullet point, charity members should exercise their right to vote in the interests of the charity for which they are a member, and charity members should be prepared to abide by decisions that are taken fairly and within the rules of the organisation, even if this does not match their own personal preferences. And the other passage that's of assistance is at MS 2612. In the right-hand column of MS 2612, members' voting obligations, halfway down the right-hand column, we're told this: members of a non-charitable company do not have an obligation to exercise their rights in the interests of the company. When exercising their voting rights, members of non-charitable companies are entitled to take account purely of their own interests. However, the Charity Commission considers that the rights that exist in relation to the administration of a charitable institution are fiduciary, regardless of the identity of the person or persons on whom the rights are conferred. Therefore, this applies to both individual and corporate members. So, from the perspective of the Charity Commission, it doesn't regard the dangers, as Sir Christopher sees them, as having any great force. There's no basis for suggesting that that guidance has led to any practical problems. The Attorney General does not think there is a problem, since he supports this appeal and agrees that there is fiduciary obligations in this case. And plainly, Parliament did not think there are practical problems, because I've shown the court section 220 of the Charities Act, MS 1775, imposing duties on members of a CIO to act only in the interests, as they see it, of the charity. So the suggestion that for the court, for this court, like the Court of Appeal, to find that there is a fiduciary obligation would cause practical difficulties, in my submission, is untenable. And it's also untenable because the Articles of Association and the memorandum make it very clear that the member can only act in the interests of the charity. Sir Christopher's other practical concern is that a fiduciary duty on members, quote, would be likely to incite litigation, unquote. That's paragraph 13.2 of his written case, MS 194. In my respectful submission, that should be taken with a large pinch of salt, when it was the judgment of the Chancellor that in the circumstances of this case, approving this grant and directing Dr. Lehtimaki to approve it was the best way of avoiding the risk of further litigation and the best way of ensuring finality to this unhappy dispute. That's the Chancellor's judgment, paragraph 153, MS 296. Then, finally, Sir Christopher's written case refers to two textbooks which state that members of a charitable company do not owe fiduciary duties. He relies on Tudor on Charities, MS 1726. I don't invite the court to turn that up, but I do invite the court to turn up the authority on which Tudor relies. And the authority on which Tudor relies is the Girls' Public Day School Trust case, which is at volume 1 of the authorities, tab 15 at MS 767. And I invite the court to turn it up because the case is not a case about a charity. It concerns a non-charitable company. One sees in the argument of Mr. Dennis Buckley for the defendant, the Minister of Town and Country Planning, at MS 770, at the end of that page, the final line, Mr. Buckley in his argument says no one would suggest that the carrying on of a private school is a charity. The question is whether the present trust was formed to carry on business for profit or for educational activities without any profit. This is not the latter case. The land cannot be held for charitable purposes unless the company is a charity. And then his lordship, Mr. Justice Roxburgh, in his judgment in the 5th line, it's conceded by Mr. Lindner, and I think cannot be in doubt, that for land to be within that section, all the purposes on which it is held on the appointed day must be charitable. There's no doubt, and this again is not in dispute, that the moment in time at which the question has to be determined is the appointed day. And then on page 406, which is MS 773, I have to look at the position on the appointed day. I have to see whether the lands of the trust were lands and interest in which was held on charitable trusts and no other, or for charitable purposes and no other. I find it impossible to answer that question in the affirmative. So the case is simply not addressing charities, and therefore Tudor cannot, in my submission, accurately rely upon it. The other point made by Tudor, and I'll leave it to Mr. Pearce for the Attorney General, because he addresses it. It concerns section 30, subsection 2 of the Charities Act, and the Attorney addresses that in his written case at paragraph 14.5b, MS 171. But I will leave that to my friend. The other academic authority that Sir Christopher relies on is Piccarda, but no reasoning is there given as to why the member of a charity is not a fiduciary, or cannot be a fiduciary. It's MS 2687, but again, I won't take time on it. Then the Court of Appeal suggested, it's paragraph 63 of the judgment, MS 245, and it's echoed by Sir Christopher in his written case, that the members of a company are likely to be better informed than the court as to the interests of the charitable corporation. Well, in my submission, that doesn't answer the arguments as to why the members are acting in a fiduciary capacity, but the suggestion that they are better informed is in any event a weak point in the present case, where the trustees on behalf of the charity have asked the court to decide whether the grant is in the interests of the charity, and the court had the advantage of hearing from all relevant persons, including the Attorney General, and indeed including Dr. Lehtimaki. The Court of Appeal said, and can I take the court to the core volume, it's paragraph 67 of the judgment, it's appendix tab 2, MS 246, paragraph 67 of the court's judgment. And it's a particular sentence in paragraph 67 at MS 246, line 5, where the Court of Appeal said, now that the Chancellor has concluded that the grant is in the best interests of SIF, Dr. Lehtimaki should obviously consider his views with care, but it remains the case, we think, that it's reasonably open to Dr. Lehtimaki to disagree. Our submission, for all the reasons we've given, subject to section 217, which I have to deal with and will deal with, our submission, respectful submission, is that the Court of Appeal wrongly sought to reduce the court's role to an advisory one. That Dr. Lehtimaki should take into account what the court had said. In our submission, the true position is that once the court has jurisdiction in relation to this question, is this grant in the interests of charity? And once the court has decided that question in the affirmative, after hearing from all interested and relevant persons, and once that conclusion on the merits is not being challenged, and it's not on appeal in these proceedings, the public interest which is protected by the court in advancing the interests of charity must authorize the court to direct Dr. Lehtimaki, who has no personal interest, who is part of the administration of the charity, and who is acting, we say if necessary, here acting in this context, in a fiduciary capacity. The court must have power to direct him to vote in favour of the grant, that is consistently with the judgment of the court. Otherwise, he is able to set at naught the judgment that the court has reached in the exercise of his jurisdiction. And the Chancellor put it in this way at paragraph 154 of his judgment. I invite the court to look at Appendix Tab 4, MS 297. At 154, His Lordship says, leaving pragmatic grounds aside, the legal basis for my decision is, in my judgment, to be found in the particular circumstances of this case. Here, both the Commission and the trustees have decided their discretion to approve the grant should be exercised by the court. That discretion has now been exercised. The discretion so exercised binds the charity and the charitable company. Its management is only divided between trustees and members for specific purposes. Here the trustees bound SIF in relinquishing their discretion to the court, and the court order will bind SIF in deciding that grants should be made. This means that, and then he deals with section 217, which I'm coming to. The member does not have a free vote in this case because he's bound by the fiduciary duties I've described, and he's subject to the court's inherent jurisdiction over the administration of charities. And then this, when the court has decided what is expressly in the best interests of a charity, a member would not be acting in the best interests of that charity if he gainsaid that decision. And in my submission, that's right. The court has decided that this grant is in the interests of charity. It is simply not open to the member to say, I take a different view to that which the court has reached after consideration of that very question and after hearing from all relevant persons in the exercise of the court's parens patriae jurisdiction. That's my second submission.
Just going on to paragraph 155, the
Yes,
Court of Appeal say the position might be different if there were numerous independent members of the company, or if the trustees had not relinquished their discretion to the court. Leaving aside the second half of that sentence, do I understand correctly from your submissions that you also support the Court of Appeal's reasoning on the first half of it?
This is the Chancellor, isn't it?
This is the Chancellor, yes.
Oh, I beg your pardon. Yes, the
This is the
Chancellor.
Chancellor, Mum.
Yes, of course. Yes.
Well, my position in relation to other factual circumstances is, and I'm not trying to duck the question, is it all depends. And I've accepted the proposition put to me by my lady, Lady Arden, that whether there are fiduciary duties and how the court will address circumstances very much depends upon the particular circumstances of the particular case.
Thank you.
I say that the factual circumstances of this case are stark and very clear indeed. And I positively invite the court not to say more than it needs to say in relation to other possible cases. It's completely unnecessary to do so. So that's the second part of my submission. If I'm otherwise correct...
Just before you leave it, Lord Panic, the point's been raised, I think, in Mr. Henderson's. If this is a fiduciary duty, is there a positive duty to vote? Or is it only a duty how to exercise your vote if you choose to vote? one can well understand that, I mean, directors, or trustees in this context, have a duty to be reasonably diligent in attending meetings and voting where voting needs to take place. It's not such an obvious concept in relation to members.
Again, my answer to your lordship would be it all depends on the particular circumstances. And in my submission, it could not be a lawful approach for Dr. Lehtimaki to take to say, I'm simply not going to pronounce on this question. I'm not going to take a view. He hasn't taken a view some, 5 years after the matter was decided by the trustees, the independent trustees, all the trustees. But were he to say, this is very interesting, but and the Chancellor has decided that the other two members are conflicted and it's all up to me, I'm not going to take a view. That would, in my submission, the circumstances of this case would be a breach of his responsibilities, both under the instruments of the charitable corporation, but more importantly, his fiduciary obligations. He must take a position. He can't frustrate the need for a decision and the views of the court in relation to this matter. But I say nothing more generally. I entirely accept there may be other circumstances where that is a more difficult question. Again, I invite the court to focus on the circumstances of this case, and I repeat that in relation particularly to a charity, I repeat Lord Simon's principle that the court proceeds by reference to experience, by reference to the particular circumstances, and I repeat what Lord Blackburn said in Leicester and Browers, that one looks, even in a private trust context, one looks at the particular circumstances of the particular case, and one should be, with respect, slow to be too absolutist about propositions in this context. That's my case. The third part of the case, can I come on to, is Section 217 of the Companies Act, read with Section 21 of the Charities Act, and the question of whether those provisions have the effect that the Chancellor had no power or should not have exercised a power to direct Dr. Lehtimaki as to how to perform his statutory responsibilities. Section 217 appears in Volume 1 of the Authorities behind tab 3. It's MS 556. Payment by company, requirement of members' approval. Section 217, payment by company. 2171, a company may not make a payment for loss of office to a director of the company unless the payment has been approved by a resolution of the members of the company. And the court will have seen that the Chancellor heard argument and concluded that Section 217 is applicable in the circumstances of this case. And there was no appeal from that decision. And that's at paragraphs 83 to 89 of the Chancellor's judgment at MS 278. The court will also wish to have in mind Section 201 of the Charities Act, which appears behind the previous tab, tab 2, at MS 549. Section 201 of the Charities Act is MS 549, 201 subsection 1. In the case of a charitable company, each of the following is ineffective without the prior written consent of the Commission. A, any approval given by the members under any provision of Part 4, transaction with directors requiring approval by members. And then F, 2, subsection 2, clause F, section 217, payment to directors for loss of office. The Commission here deferred its decision under section 201 until after the judgment of the court, very sensibly. And the Chancellor explains that in paragraphs 149 to 150 of his judgment. Now, the approach taken by the Court of Appeal to section 217 appears at paragraph 64 of the judgment, which is in the appendix behind tab 2 at MS 245. Paragraph 64, the Court of Appeal says in the present case, MS 245, in the present case there is a further reason for thinking that the court could not be justified in intervening unless it were apparent that Dr. Lehtimaki was acting improperly. Between them, section 217 and section 201 require a payment such as the grant to be approved by a resolution of the members of the company with the prior written consent of the Charity Commission. It is significant that Parliament has entrusted this responsibility to the members of a company, not only for the generality of companies, but specifically and expressly for charitable companies. The Chancellor considered that the Charity Commission should be afforded its statutory opportunity to consider whether to approve the making of the members' resolution under section 217, but made an order denying Dr. Lehtimaki any choice as to whether to approve the transaction in accordance with section 217. In effect, Dr. Lehtimaki is being prevented from playing the part that in the circumstances Parliament has assigned to him. We do not think that it could be appropriate to interfere with the statutory scheme in such a way unless there were impropriety. So the Court of Appeal's approach, this court will see, was not that section 217 precluded the court from telling a member how to exercise his vote. The conclusion of the Court of Appeal, rather, was that the circumstances in which the court, the Chancellor, could tell Dr. Lehtimaki how to exercise his vote were circumstances confined to circumstances of impropriety. And we respectfully challenge that conclusion.
Perhaps they should have gone further.
They should have gone
Further.
and found impropriety.
No, and found that if the statutory power is confined to the member, then the court cannot exercise it.
Yes, I respectfully agree. The Court of Appeal could, in principle, have found that as a matter entirely for the member. I'm simply making the point, which is not determinative, I recognise, that the Court of Appeal did not suggest that it's a matter for the for the member in all circumstances. Now, our approach is this: we say to this court that Section 217 does require a resolution from the member, but what Section 217 does not address is the distinct question of the powers of the court to direct the member how to vote. I entirely accept that other than in special circumstances, the court would not tell a member how to exercise his statutory function. The court would leave it to the judgment of the member. My submission is that Section 217 does not preclude the court from telling the member how to perform his functions in the interests of charity, where the court takes the view, and reasonably so, that this is a matter which it is either expedient, to go back to my earlier submissions, or necessary, because I say both apply here, to protect the interests of charity, this being an exceptional case where the trustees on behalf of the charity have surrendered the discretion to the court, their discretion to the court, and the court has decided the substantive issue of whether this grant is in the interests of charity. I say the court is at least entitled to take the view that it is appropriate to direct the member in the circumstances of this case, when he performs his function, not to adopt an approach inconsistent with the finding that has been made by the court, especially when the member is part of the administration of the charity and owes fiduciary duties.
I'll ask you, putting a hypothetical example, say the Charity Commission had agreed with Dr. Lehtimaki, or does agree with him, and it was unwilling to grant its consent under Section 201. Would the court direct the Commission to grant its consent?
In my submission, yes. For the same reasons, the Charity Commission has referred to the court the substantive question of whether this particular grant is in the interests of charity. And it's referred the matter to the court. Your Lordships and Ladyship have seen the reference because the Charity Commission took the view that this was a matter that it is more appropriate for the court to decide than the Charity Commission. Once the court has determined that substantive issue in favour of the grant being in the interests of charity, I say it could not be open to the Charity Commission to stand in the way of the implementation of a grant which has been held to be in the interests of charity. So I would make the same submission in relation to that. And the reason for this is that there's nothing in Section 217 of the Companies Act, or indeed Section 201 of the Charities Act, which ousts or indeed reduces the jurisdiction of the court to determine in an appropriate case what is in the interests of charity. I say that Section 217 was not intended, nor is there anything in its content to suggest that the powers of the court, if I'm otherwise correct, the powers of the court are to be reduced or are to be subject to the veto by the member. And it would, in my submission, be a quite remarkable proposition that Parliament can have intended where the court otherwise has jurisdiction to decide what is in the interests of charity and otherwise has a power to direct a part of the administration of the charity who has a fiduciary duty, if Section 217 were intended to provide that person with a veto. Now,
It couldn't it be said, sorry, could I ask you a question about that? Could it not be said that Section 201 was really dealing with the case that the resolution had actually been passed, and that it was really a regulatory section to catch up with changes in the law which had been made since the previous Charities Act, and all that the Charities Act 2011, the subsequent act, does is qualify the authority given in the 2006 Act to pass certain resolutions, one of which I know predates the 2006 Act, namely Section 217. But in other words, it's dealing with not the situation of the prospective application to obtain directions from the court, but of protecting the charity where the resolution has actually been passed.
Yeah, I see the force of that, my lady. I do see the force of that.
I'm not sure. I'm not sure it really addresses the point of it. I mean, obviously, the point the Court of Appeal was making is that if Parliament has confided a power to a particular body, then it intends the power to be exercised by that body, and it's not appropriate for the Court to intervene by directing the statutorily authorised body as to how it ought to exercise its statutory power.
I understand that, my lord.
I
but
mean, it's a very familiar argument in other contexts.
It is, and the answer that's often given by courts is that the statutory power is given to, for example, the Home Secretary, but in an appropriate case, that fact does not prevent the court from telling the Home Secretary how to exercise that power. Now, obviously, everything depends upon the circumstances, the statutory language, the circumstances in which the Home Secretary has acted, the reasons why he has acted. But I do not accept that the mere fact, important fact, but mere fact that Parliament has conferred a particular responsibility on a particular person prevents the court, where it is otherwise appropriate, from telling that person how to perform his or her responsibilities.
Well, the Home Secretary example rather makes a point, because there the court exercises its supervisory jurisdiction on the basis of unlawfulness. And if it identifies the Secretary, I mean, it doesn't go into the merits. It's looking at whether the power has been exercised lawfully. Now, the whole point here is that this is merits-driven review based on the court's assessment of what's in the best interests of the fulfilment of a charitable object.
Your Lordship says merits, but with respect, that's not necessarily true. There are contexts in public law where the court does take upon itself responsibility for deciding the merits. It might be a precedent fact case. It might be a case under the Human Rights Act, or might be a case under... I mean, it all depends. Normally, I accept the court's responsibility is supervisory, but we're back to the issue that I argued under my first and second propositions, which is that here we are dealing with a context in which, A, the trustees on behalf of the charity have surrendered to the court responsibility for taking a decision on the merits, and secondly, it's a context where the court, by reason of its parens patriae jurisdiction in relation to charity, has a special responsibility for deciding what is in the interests of charity. So I with respect, don't accept that absent section 217, we're in a legal context where one leaves it to the statutory decision maker. And I say that given all of these very unusual circumstances, the court has a jurisdiction with which section 217 is not intended to remove. Of course, the court will act with care, it will act with sensitivity, it may be slow to intervene. But the point taken against me by my friends, and indeed by the Court of Appeal, is that the Chancellor had no business telling Dr. Lehtimaki how to exercise his statutory function absent some form of impropriety. That's what I don't accept.
Is the perhaps unspoken but essential plank in all this your submission that the only question which arises in this context under section 217, in the context of a charitable guaranteed company with a small number of members, whether the proposed transaction, that is conferring of a benefit on a departing trustee associated with it, is in the interest of the charity.
It's the same
Because if that's the only question, the only merits question to be decided, you presumably say, well, the court's already decided that merits
Well, that is my
question
case.
between the appropriate parties and has joined Dr. Lehtimaki for that purpose.
Once the court accepts, and my submission the court with respect should accept, that Dr. Lehtimaki has no other question to ask himself because he's a fiduciary or because he's part of the administration of the charity, however one puts it. Once the only question for him to ask himself is, do I think that this grant is in the interests of the charity? It follows, as my lord puts to me, that that very question has already been decided by the Chancellor on the merits, and decided by him because he was asked to decide it. And therefore the question is very stark indeed. Is it really open to the member? Was it really the intention of Parliament that a member could say, in the exceptional circumstances of this case, very interesting, Chancellor, but I take a different view? And in my submission, no. Parliament cannot have intended by these words to allow someone who is part of the administration of the charity, who has a fiduciary role, to set at naught, to veto the judgment of the court exercised in its responsibility, in the exercise of its responsibility for charity, with the benefit of the views of the Attorney General. It's simply not the business of Dr. Lehtimaki, in my submission, to take any such approach. And I say a much more specific statutory provision would be required if the powers of the court were to be limited, if the court were not to have a power to give directions, if Section 217 were intended to reduce what is otherwise the jurisdiction of the court, if I'm right on my earlier submissions. There's two authorities that I should mention. One of them is a wardship case. It's to be found at volume 5, tab 87. I mentioned earlier on that the parens patriae jurisdiction of the court in charity bears some relationship, some connection with another similar jurisdiction in family law, in wardship. It's volume 5, it's tab 87, and it's MS 2375, in re S an infant. And the question arose here as to whether the court retained its wardship jurisdiction in the light of Section 1, subsection 3 of the Children Act 1948. And that provision is set out, the court will see, at MS 2377, it's page 485 of the report, MS 2377, at letter C. And Section 1, subsection 3 of the Children Act 1948, which says, nothing in this section shall authorise a local authority to keep a child in their care under this section if any parent or guardian desires to take over the care of the child. And the circumstances of this case were that a child had been in the care of foster parents for 10 years, whereupon the natural mother wanted him back. She wanted back her son, and she relied on this statutory provision. And the foster parents applied for the child to be made a ward of court. And the issue was whether, in the light of that statutory provision conferring the right on the parent, the court could exercise its wardship jurisdiction. And Lord Denning dealt with this at MS 2379, page 487 of the report. picking it up at letter G, 2379, letter G. And his lordship says, it seems to me to be very important that the jurisdiction of the Court of Chancery over its wards should be maintained, even when a local authority has taken a child into its care under Section 1 of the Act. The reason is because the statute gives to a natural parent the right to demand that the local authority give the child up to him or her if he or she desires to take over the care of the child. The imminence of such a demand is a very relevant consideration. Their care may be terminated at any moment. That puts the welfare of the child at peril. It may be taken away from a good home with foster parents and removed to a very undesirable home with its natural parents, whom it doesn't know in the least. In order to avoid this peril and secure the welfare of the child, the jurisdiction of the Court of Chancery must be maintained. After all, the Court of Chancery exercises the power of the Crown as parens patriae, and its jurisdiction is not to be taken away without express words, and there are none in the statute. The court would not, of course, interfere in any ordinary case with the care and control being exercised by the local authority. Nevertheless, the fact has to be faced. Emergencies may arise, threats may be made, under which the natural parent may seek to take the child contrary to the best interest of the child. If there's any danger of this happening, the court should continue its wardship. It should receive evidence, see what is best for the child to be. The undertaking given by the foster parents, that was an undertaking that the child would be returned to the parents if appropriate, is no bar to this overriding jurisdiction of the court. And that's what I rely upon. Now, I entirely accept that the court would be slow to exercise its jurisdiction in the light of a statutory provision that confers some right, some entitlement, some power on another person. But what I don't accept, with great respect, is that Section 217 removes the jurisdiction otherwise enjoyed by the court to decide what is in the best interests of the charity, and in particular whether this grant is in the best interests of the charity. You need some express words in the statute which remove the powers otherwise enjoyed, the fundamental powers of the court in its parens patriae jurisdiction in the family law context, or, I submit, in the charity law context. That's the point. I say express because Lord Denning refers to some express words. The court may think that one could envisage a case where the powers of the court are removed by necessary implication. And I wouldn't wish to be too absolutist. And I have in mind the other line of authorities that the court would be very familiar with, that a fundamental principle of the common law is only taken away by a statutory provision where this is expressly stated or appears by necessary implication. That's the Morgan-Grenfell principle. So,
Lord Bannock, I think you're absolutely right to remind us of the difference between the existence of a jurisdiction and the exercise of a jurisdiction. And at the back of my mind, I think there are cases in the 80s in relation to wardship, which says, well, we may have this extremely wide jurisdiction, but in these circumstances we won't exercise it. Was any thought given in this case to whether, if you're right to say there was jurisdiction, it was an appropriate case for exercise at this stage, in advance of the first respondent making his decision?
well, it was. I mean, the Chancellor was very concerned that it was highly desirable to bring an end to this litigation. What would be exceptionally unsatisfactory would be for the Chancellor to say, well, I think that this grant is in the interests of charity, and I so declare, and I very much hope that Dr. Lehtimaki in exercising his functions under Section 217 will act accordingly. But if he doesn't, then I will have to consider whether to make a direction. He could have adopted that approach, but he didn't, and in my submission, wisely so, because he had all the circumstances of the case before him, he had all the relevant people with an interest before him, he heard detailed argument as to whether or not this grant is in the interests of charity, and having formed a view on that after being asked to do so, in my submission, it was at least open to the Chancellor to enforce his decision. And it's no part of this appeal, hasn't hitherto been part of this appeal, for Dr. Lehtimaki and Sir Christopher to say, well, the Chancellor has power to direct, but he should have waited to see. And in my submission, given that we're now 5 years on, it would be a very I respectfully submit, it would be a very unsatisfactory solution for there to be yet further potential litigation were Dr. Lehtimaki to take a position. I mean, it's one of the unsatisfactory features of this case that even now, 5 years on, Dr. Lehtimaki is not saying whether he approves or he disapproves of the grant. His position is, it's for me, and I will tell you in due course. That's my response, respectful response to your Lordship. So that's the authority we rely upon. There's one, I think I've got 15 minutes left, and I certainly won't exceed that, but I want to deal with the Christ's Hospital case, which my friends rely upon, and there may be a couple of other matters that those next to me and behind me tell me I need to deal with, but I will finish at 2:15. Would that
Very
be
well,
a convenient moment?
It certainly would. 2 o'clock.
Thank you.